All right, good afternoon, everyone. Can everyone hear me? Great. So I'm going to be a little bit loud, and I'm going to move around a little bit. If that irritates you, I apologize. But I would like to start by thanking the other speakers before me and thanking the organizers particularly. I mean, this is a fantastic conference, isn't it? I mean, look at the information that we are getting out of these speakers. I mean, and the different styles they have and the different ways they have of presenting it. We are really learning. It's funny, this sign up here says class will resume in 15 minutes. Apparently that's the tells. I feel like I'm in class. I feel like I'm a student. I feel like I'm learning. And that means that the conference is working. And I hope that I can give you at least one tidbit of information today that you can take with you. And if I do, then I will have succeeded. Now, my firm is Clarquist. We are an IP boutique in Portland, Oregon, in the United States. And I'm here to talk about controlling patent costs and prosecution in the United States. Now, I take a risk here in that you might think that we're trying to say, oh, you need to just reduce costs and go to the lowest possible price point. Well, as was talked about very rightly by the preceding speakers, that's not the way to go, right? We want to control the costs. Sure, we may want to cut costs. We may want to increase costs, right? We heard about the nimble and the adaptive patent department. I think that's just wonderful advice. So this presentation is licensed under Creative Commons. And here's what we'll talk about today. First, cost control concepts. I like to introduce some vocabulary. This is a serious topic, actually, and we can look at it from a philosophical standpoint and come up with terms, right? Make our own ontology, if you will, the vocabulary to talk about this topic so that we can get on the same page and we can make some progress today. And for those of you who have never taken any interest in patent prosecution at all, that's fine, because I'm going to do a cradle-to-grave march through from finding the inventions to the maintenance fees. Now, there's some folks here have already covered it, I think in even broader terms, cradle-to-grave, right? And I think they did an excellent job. Mine's going to be a little more nuts and bolts. I'm a patent prosecutor. So we have folks here that manage portfolios. We have people here that do the big litigations. I sit behind my desk and I type out patent applications. That's what I do. So I'm a prosecutor and I work for an outside counsel firm, so that's the perspective I bring. But I think a lot of these techniques can also be applied whether you're in-house or whatever your situation is. So let's go ahead and we'll look at these different parts of the life cycle. Finding the inventions, right? We talked a little bit about that, the harvesting. Filing on the inventions, you have to do that. Prosecution. That's the nuts and bolts of going back and forth with the patent office, right? And then post-issuance, there are some things there that we can do. And then there are the dreaded maintenance fees, right? You can spend a lot of money on maintenance fees, and that's a good way that we can control costs, so we'll take a look at that. So the theme that I have today is that some cost reductions hurt quality more than others. There are some ways where you can cut costs, and you might even increase the quality because of what you've done. There are others where you really have trouble cutting costs. And so making that informed decision is what we're trying to do today. We're trying to figure out how to do that. There is no cookie-cutter approach, as was rightly said earlier. You need to integrate that patent department into the organization, into the R&D. But let's get started. The concepts. First, we need to set clear goals, right? If you go into websites, particularly in the United States, all these lawyers are telling you, we know your goals. We will understand your goals. Well, they're correct. That is the first step, is knowing the goals. And it was said earlier, that's a big part of this whole picture, is figuring out what the goals are. Some folks, they have a newer patent program. They might not know what their goals are. Some folks may have a patent program that's been around for 15, 20 years. Maybe they have different goals this year than they did last year, but they probably have some goals. Then we look at cost versus risk. And going back to goals for just a minute, I've had associates who tell me, I went the extra mile. And I say, okay, you went the extra mile, but did you go in the direction that the client wanted you to go? Right? That's the idea of the goals. So let's move on from that. Cost versus risk, I already talked about that, informed decision. Addressing the rules. Now, this is stuff that you have to do if you want to get a patent. I'm talking about patent prosecution. You have to file the application, you have to get the signed declaration or file a substitute statement. These are things that you have to do. So that's actually an area where we can reduce costs because we're doing these things repetitively. These here are a little harder. These are a little harder to optimize costs, figuring out how to fully understand the invention, fully understand the prior art, right? That's the searching part. Fully describing the invention, and then fully claiming the invention. This is hard. If this is easy, you're not doing it right. That's what I always say. Now, but what can happen here is some of this work can maybe be shifted to folks who have a lower cost, right? Do you really want to pay some fancy patent attorney to go out and do all of your searching for you? Well, you could do the searching beforehand. And even identifying the invention. Do we just send an email, or do we actually have some carefully written materials that describe the invention? And that can help reduce costs. This is another concept I'd like to talk about. It's called credence services. And I think this is sort of a big think type of thing, and I'll ask you to sort of go with me on this. And I thank my law professor at the University of Virginia, Lillian Bevere, for this. I did not come up with this. There are different kinds of goods and services. Some goods and services, you know what they are before you buy them. You can look at it, it's on the shelf, you take it home, you know what it's going to be. And there are some goods and services that you don't know until after you buy it, after you get it home, after it's been provided. Then you can look at it and you say, well, that wasn't so good. Or maybe it was good. There are some services that even after you pay for them and after you get them, you still don't know if you've been provided good services or not, right? That's legal services. And that's one of the major problems that we have with controlling costs, is we may control costs, but the services may be going down. We don't know, right? Could be years until we figure it out. It's tied to patent valuation, and as was rightly said in the presentations beforehand, we need to have an idea on that. We need to know what patents are valuable. We need to measure that. Otherwise, we can't tell. Now, one way you can increase value is by decreasing costs, right? Because then you've affected that part of the revenue. But another way is to increase quality, better target, blah, blah, blah. And you really know how well you're doing when the C-level executive walks up to you and says, do we have anything on this? And the answer is, no, we don't have anything on that. And you thought you did, right? So this is the type of thing that we want to revisit these goals to make sure we're on track, right? We just have to do that. In today's world, the world changes every quarter, right? So we can't stay with the old goals. Something might happen when we have an acquisition, what have you. And everything I say is subject to an exception. I like to think I know what I'm talking about, but clients have other ideas. They trump. I'm just outside counsel. And then looking ahead and being nimble. As was rightly said in the earlier presentations, integrating the ability to change and to rebalance and to grow and to prune from the beginning. Cataloging the IP, knowing where we're weak, knowing the white space. Being told we need to do something over here and not saying, oh no, how are we going to do that? Saying, okay, we're going to do that. We're going to ramp up here. We're going to prune back here. So that's it. That's all I'm saying. We'll talk about finding the inventions. Now, I don't have a lot of time, and this presentation could go over, so I'm going to go through this pretty fast here. This is essentially what we talked about before, where we identify the inventions, the harvesting part. It depends completely on the culture of the organization. Could be you provide a monetary incentive. Could be you have some sort of accolades that are given. Or it could be that you just work together with the R&D department. It could be anything. Patent Review Committee here, this is a situation where the risk here is that the Patent Review Committee simply rubber stamps everything that goes through. And then you end up with some patents maybe that aren't worth anything, and the ones that you wanted, you aren't getting. We need some active involvement. That's already been rightly said, so I don't need to repeat that. Combining applications, you have 2 or 3 inventions in one application, there's a risk there. The risk is that some of the stuff is left behind. Searching is something that I think, we have very few clients who don't search anymore. It's just risky, because what you're doing is you're paying lots of money for something that may be worth 0, right? So you do the searching. You can spend an unlimited amount of money doing searching, or you can spend a smart amount of money doing searching. Then filing on the inventions, all I had to do here is talk about the fee structures, and I think that was on one of the slides earlier that someone talked about. In the United States, it's 3 independent, 20 total. If you file a patent application with 6 independent claims in the United States, and you pay all those excess claims fees, the U.S. government will thank you for the contribution, but they won't actually examine the claims, right? Because they're going to restrict it out, and you've spent all that money. So be aware of that, and be aware that most of the times you want to do 3 and 20. Exceptions, right? There are exceptions, but that's multiple dependent claims don't make a lot of sense in the U.S. Page counts, someone already rightly said that. Know about small and micro entity. If you represent a firm or a company that has a small number of employees or individual inventors, not everybody's a multinational corporation, right? Individual inventors get a discount. You can get up to a 75% discount on government fees. So learn these rules and see if you apply. Declarations, powers of attorney, these things we can do, we can reuse. details, EFS. I'm going to skip through this stuff. Now, prosecution. In the United States, as I'm sure in many jurisdictions, there is a publication of the patent application. When that application is published, there are certain acts that can be taken, namely proofreading it to make sure that things are there. If you don't do that, there's a risk that you actually are losing some rights. You're losing some opportunity for damages. Most of our clients have decided that that's not of concern to them. They just don't care about that, and they're going to just do nothing. They instruct us to do nothing with publication. Maybe, if you wanted to address that risk, you could look at it yourself rather than having a law firm do it. You could have some service do it or something like that. Avoiding RCEs. Now, here I am going to slow down a little bit because I think this is one place where you can really save a lot in prosecution. And again, you know, as was rightly said by someone else, having that picture claim, having that range of independent claims, not just dependent claims, independent claims, having every independent claim saying essentially the same thing means that you're probably going to have a long and drawn-out prosecution. Now, you might say it shouldn't be that way. I would agree with you. This is my observation. If you have the picture claim, you have the narrower claims, you have a range of claims, you're more likely to encounter fewer RCEs and pay less overall. Okay? Examiner interviews. They can be good. You might spend a little extra on an examiner interview and avoid 2 RCEs. And then there's cross-citation. I'm going to move on from that. The post-issuance, just like I said, there are some things that happen at publication. When a patent issues in the United States, there are all these things that you can do and you can monitor and you can check. You can proofread the case, but a lot of our clients are doing no or limited proofreading. Maybe they're just looking at the claims. There's a broadening reissue, a reminder, and a deadline 2 years after issue. A lot of our clients are saying, don't tell us about this, we'll watch this ourselves. Don't have the law firm do that. No patent term adjustment checks. The patent office gets the patent term adjustment wrong sometimes. But it's very rare. And, okay, if you're pharmaceutical, you are paying for this. Because as a pharmaceutical, you're looking at big revenue every day to the end of the life of the patent when you hit the patent cliff. But if you're an IT company, do you really care what that patent covers in 20 years from now? Well, maybe you do, but many of our clients have decided that they're not going to worry about that. There are some risks here, right? You may be entitled to more term, and you didn't ask for it. But it's rare, and you're paying for it. So you can just cut these things back. And finally, the dreaded maintenance fees. And I think, as was said, I mean, I almost feel like I don't need to say anything because all the previous presenters, it's great, the advice, the observations that were being made. You have to plan to pay the maintenance fees from the beginning, right? That's all part of the cataloging, right? What you don't want to have happen, and I've seen this happen time and time again, is where the CFO goes into the patent department and says, we need to cut 10% because we just don't have the funds, we can't justify, we want to shift this into something else. It'll be in the patent department, but it's not going to be paying maintenance fees. We want to file more in India, we want to file more in Europe, or whatever it might be. Then the patent department is sitting there looking at 10,000 patent assets and trying to figure out how to cut 10% of the maintenance fees. Instead, the better approach is to plan to prune from the beginning. As was said when we're doing the cataloging, maybe that's one of the things we put into the catalog. When the patent issues, we say this is a patent that is a strong candidate for pruning. Then when it comes time to prune, instead of having to look at all 10,000, maybe you only have to look at 1,000 or 2. So you see the wisdom of that, right? That's just still common sense. But we all get so busy in our day-to-day practice that we don't see these things. A lot of these things, and that's why I like these conferences, a lot of these things are common sense if we just stop and we think about it, right? And that's one of the reasons I like these conferences, because I learn that way as well. And the monetization has already been covered, right? You can auction or sell, you have an acquisition, you acquired all these patents, that has nothing to do with your business model. But of course, you want to be careful about keeping a license because you don't want to be sued on a patent that you sell, right? So these are some resources for you. The AIPLA Economics Survey, you can look for that online. And if you're a member of AIPLA, I like to tout that organization. If you're a member of AIPLA, you can go there and see the cost per stage in different subject areas. Pharmaceuticals, more than mechanical, right? You can see that. PTO fees, The database, I think everyone already knows these things, but I thought I'd throw them up there. So thank you very much for your time. I appreciate it. Hope it was helpful.